And Mr. Richards does appear via Zoom, represented by counsel's Attorney Hargrove and Milholm. Good morning.
Good morning. All right, Mr. Richards is in the custody of the Walworth County Jail. Mr. Richards, can you see and hear me okay?
Yes.
Okay, I can also see and hear you clearly. I just want to let you know again, if I'm turning my head, it's because I'm looking at you. That way I can see you if you need to say anything today. All right, is the state in compliance with?
The hearing begins via Zoom. The defendant appears from jail. Attorneys are present, and the judge immediately acknowledges a serious pretrial session. Almost instantly, discovery issues are raised, setting a tense tone for what's to come.
Victims' rights.
Yes, the state is in compliance and there are victims present.
All right. Well, we are on for a final pretrial today. I've received now 2 letters in the last 24 hours, which took me back at first because I was very concerned about the content of the letters, the issues related to discovery, and particularly the amount of time and energy that we've all spent trying to keep this case moving forward. Attorney Hargrove, I'll let you make a record of that letter and the contents and your request.
Yes, thank you, Your Honor. If the court would indulge me. So we did end up being compelled to have to file this adjournment request. Just to give a procedural history, I believe it was the last time we were in court, approximately 3 weeks ago. We were notified that we were receiving a Cellbrite dump of Mr. Richards' phone, to which, as I try to be diligent about it, I did make a record to the court. I believe the court made a statement about that would be voluminous. You do have a team of attorneys. Hopefully we can get this reviewed. If there's any subsequent investigation, discovery, things that impact the defense preparation, that hopefully we get that done. At that time, I thought it was dubious, but I was committed to doing that. And so we continue to do that. And that was approximately 23 gigabytes of data, basically from his phone. There have been some issues with the jail as their laptop somehow had a broad width or sufficiency limitation that was preventing him from viewing that material, which is why now we've had to print it all out and we'll be dropping it off after this hearing for him to review his specific Cellbrite data. After that, there was some correspondence between myself and the state because as we were routinely reviewing it and assessing it, not only one of my associates, Attorney Milholm, but myself and 2 of the assistants at my law firm reviewed it and said, we're still not seeing the information of KS's phone. And I thought the dump was going to be of both of theirs, especially because it was so voluminous. It turns out that it was not there. We checked multiple times. I did confirm with the state, and Lieutenant Hellberger, who was extremely helpful, said he'd be willing to assist us with it because they thought it was something to do with the access on our end. I confirmed again.
The defense reveals massive digital evidence dumps, tens of gigabytes of phone data. Files are delayed, incomplete, and difficult to access. The court begins hearing about printing issues, corrupted files, and missing components.
And no, it's not there. Then they said they were going to drop it off to us. And just to back up a little bit with the Cellbrite data, when we made that record that Friday, they did end up dropping it off at a satellite office. It was after hours. So because that building manager wasn't back till Monday, we picked up his Cellbrite data that Monday and then immediately began trying to download it, access it, and review it. Once we did have that confirmed, we, moving back to this week, we did get the second one. They confirmed that they were going to bring that, and he did. I don't know if it was him because I wasn't at the office right then, but someone did drop it off at our front desk, and we began opening and trying to access that. Again, for context for the court, his was 23. The one we just got is 89.3 gigabytes of data, which is reams and reams, I'm sure as the court would know. So I immediately, after I saw that and knew, okay, reviewing thousands of pages in this type of case, 8 days before trial, well, I could try to do it with 23 gigs. I'm not going to be able to do it with 23 and 89. So we were already scheduled, myself and DA Wiedenfeld, to have a conversation regarding the case, any type of potential resolution, any things that the court directed us to do, including the instruction the court was going to give regarding media or signage and anything like that. We did have that discussion. DA Wiedenfeld was very helpful, but I told him, I said, given that I just received that, we talked at 11, It was dropped up at my office at 10:08 a.m. I said, I just received that. It's downloading for the court's edification. It took 4 hours to download. It didn't get downloaded until 2 p.m. yesterday. So I explained to him that it's still being downloaded. I said, well, I'd love to be superhuman. There's no way I could be effective in reviewing all of this in 8 days. And as someone who also does appellate law and is litigated to the Supreme Court, I absolutely know what the Court of Appeals would say, that you should have asked for an adjournment because any mistake is going to fall on the defense if you were not adequately prepared. So we discussed that. He did highlight the fact that he believed that they had sent it to us before. And I said, I do not have any Cellbrite data. To specifically reference the letter of the states, I know it stated that they had sent it back in May. We've talked a few times. It was corrupted on their end. We never received it. And the way these files work, Judge, it's not as if you go into it and it says, this is the Cellbrite data, click on it.
The defense explains the scale is overwhelming, hundreds of gigabytes, thousands of pages, and ongoing downloads. They argue there is no realistic way to review everything before trial, raising immediate fairness concerns.
Oops, the link is corrupted. There are tons of links that click to tons of different documents that you have to go through repeatedly, print, sign, give yourself a list. And in that, if the court would have looked at that last adjournment letter they referenced, which I also have to make a record on, in that there was no reference of Cellbrite because based on my review of everything we received, which was about a little over 70 gigs of data, there was not Cellbrite in that. And I think D.A. Wheatonfeld is correct that when he went back and looked, it was corrupted, which means it was not properly transported, or it didn't show up on our end, or it didn't even send out from them correctly. So I think he's accurate that it was corrupted, which is why they couldn't access it. And he's also accurate that he reached out to me once he realized that, because we were waiting on that. But to be clear, just to give a full, complete record, Judge, I do have to address the letter that, because it's almost positioned as if these are multiple requests from the defense. That last letter was within a year of the preliminary examination and arraignment. And as case law makes it very clear, the case does not start until arraignment, which was in November of 2024. We had all agreed that it was an aggressive timeline to try and set it for that. I made repeated records that I did not feel comfortable scheduling a trial when discovery was still outstanding. When we finally filed that letter in August, from the state's own proclamation, they were awaiting multiple things from the Wisconsin State Crime Lab. We had not received the ballistics report, and there was still outstanding discovery. And so I want to make it clear that that was not some falling or some derelict behavior on the defense's part. We literally were still in the reciprocal discovery stage. And so we were not asking for an adjournment because we failed in some way or respect. We were asking for it. I actually think it would have been more aptly put as a joint request because the state didn't even have all of their investigation completed as we're awaiting reports. So just because that was referenced in the state, I feel the need to make the record clear that we're not coming before this court again saying, Judge, we need more time. I try to always keep the court abreast of how I'm thinking and what I'm receiving. And so we're here now simply because whether or not it's referenced in reports, the discovery statute, that is not satisfied. Also that reference in the state's letter, the discovery statute says you are simply to make it available. We did not have it, it was not sent, and like the DA said, it was corrupted. Once I got it, we literally have been doing 14-hour days reviewing his materials and taking semi-weekly trips to the jail, being told by the jail, well, we can't get it on the laptop has too many things, we're going to purge it. And now we're like, okay, well now we got to print hard copies and we got to bring it over to him. Can you make sure he sees it? Because I'm ethically required to also make sure that my client can review.
Both sides discuss missing Cellbrite data, corrupted transfers, and unclear file delivery issues. The prosecution insists they provided discovery, while the defense argues it was unusable or incomplete.
The discovery, because there are certain things that he may not know until he looks at it, or it may change his position in the case. And so I have to be diligent, and I would be far more bold if this was a battery or a substantial battery. This is one of the highest charges in the state, and it's not only something the defense waits for the state to prove, as I've put everyone on notice of, there is also an affirmative defense, which means then I become the prosecutor and have to prove something beyond a reasonable doubt. And so this evidence and the things I have to go through that impacts my investigation is highly imperative. I couldn't think of something more imperative than possibly contemporaneous statements and texts as this is leading up to that fatal fateful incident. So I do not do this lightly, but I just want to make it clear this is not based on some derelict behavior of the defense, which is why I've tried to keep everyone abreast of it. We've already started. We were up till 1 in the morning yesterday looking at it after it just got downloaded. And I would not be here, just like the court said, for all the time and money we've expended compelling this court to adjourn unless I thought it was absolutely necessary. But there is no way with 89 gigs of data that I have to go through, assess, discuss with my client, and determine how that affects any potential defense or affirmative defense. There's no way I can do that in 8 days, having received it yesterday. For any matter or anyhow we can play hot potato or you should have known or look, it was referenced but it was corrupted, that's of no consequence to me right now. My biggest thing is that I have to effectively represent Mr. Richards. And if this was not imperative, I would look at it and keep moving. But this is central to what we're going to be adversarial on in the trial. And that is why I had to put it on. And the moment I noticed it, that is why I filed it right then. So the court was not caught unaware and we just waited until we showed up in court today. So the moment I knew they were giving it to us and I was accurate that it was not in the last download from 2 weeks ago, I put it before the court. And that is the only reason I'm asking this court for that, because I'm frustrated as well, to be quite candid with the court. I think all of us are. So I appreciate that, but I have to do that. It's just my ethical and directive from the high court in situations like this. Thank you.
All right, I think it's important that the victim's family and Mr.
Defense counsel strongly argues ethical responsibility and inability to prepare. They emphasize that key evidence, texts, and phone data could shape the entire case strategy, making delay unavoidable.
Richard understand the volume of this discovery.
Yes, ma'am.
You said 23 gigabytes and 89.3 gigabytes. I can have a physical grasp of how much that entails, but when you printed it for Mr. Richards to review it in the jail, how many pages was it?
I can tell the court that, one, it wasn't even everything because it's also pictures and whatnot, but it was well over 1,500 pages. So if you're looking at a paper in the sheets, just 23 gigabytes is going to stand at least about here if you print everything. My biggest thing to start with him, because like the African proverb, the best way to eat an elephant is one bite at a time, was to start with his messages. And so that comes to about here. And just for everyone's edification, it's in about 6-point font, and it's listed like this in charts, every text. And so you could imagine if it was in 12-point font that we could comfortably read, it would be 3 times that size. But it's actually landscape style, and it's like 6-point font.
And then the victim's phone had
Approximately
more
3.5 times that.
More than triple. All right. And you haven't even started to try to print that and go through it?
I've started, but that would have been last night. So it's not even fully printed, and I'm still waiting which I have to drop off to the jail, his phone dump.
All right. Based on your tone here with the court, also your demeanor with the court, I understand that you've been trying and you've been as diligent as you can, and you also recognize the gravity of the request you're making today. So I appreciate the extensive record that you made, because I think it's important that everybody understand the issues here with bringing a case of this severity forward. Attorney Wienfeld, your letter got pulled through this morning. I had a chance to review it quickly. Could you also outline your request for the record?
Sure.
And particularly as it relates to this, I thought it was an issue with the reader, not that the material itself was corrupted. Could you help me understand that?
Right, and I'm not a tech expert, but I'll do the best to explain my understanding of the situation. But I guess I'll start by also saying that
The judge questions why such critical digital evidence issues were not identified earlier. Frustration builds as he highlights years of delays, jury preparation, and the massive logistical effort already invested.
I agree that the issue here, at this stage is, can the defense be adequately prepared and be effective in trial? If they can't be adequately prepared and effective for trial, I agree that the trial needs to be adjourned, because we don't want to create appellate issues for this case. But in terms of discovery being turned over, My office did receive both of these downloads very early on in the case. They were both provided to, what we had for downloads was provided to the defense in July of 2025. Those are both files labeled.
Are they just like links within a link within a link, or are they, I mean, are they easily identifiable?
Right, they're labeled files, but obviously there's a lot of discovery in this case. So these were compressed files, so they come through as a compressed file saying like digital discovery part 1, digital discovery part 2. You open the compressed file and there's going to probably be 10 folders within that file. One folder might be labeled autopsy photos, another folder might be labeled body cam video, and within some of those folders there's even more photos. One file might be labeled downloads, and then within that it might say cell phone download, Snapchat reader, different things like that. But both of those were within those files. Obviously, law enforcement had reviewed those cell phone downloads already. They're referenced in the reports. So we thought we had provided those and that they were in a format that could be accessed. It was when we were preparing for trial in early May that we had problems putting those onto a flash drive or printing parts of them so that we would be prepared for trial. So we immediately requested one. It's my understanding that what we received was the data, but not the Celebrite reader, which you would need to have in order to read the data. So we got a new copy that included the reader. We then tried to provide that digitally to the defense. That didn't work when it went through digitally. I don't know specifically if that's because there was a file corruption with that digital copy or if it was difficulties with sending the reader. I don't know that part of it. But obviously then we tried to troubleshoot with law enforcement, and I think ultimately it was agreed to just provide a flash drive containing the reader and the download so that they'd be able to directly access it rather than trying to submit it through electronic discovery. And from there, the timetable, picks up pretty consistently with what defense explained in their letter as well, which is that we went back and forth trying to make sure that they had access to it, that they were able to open it, that they were getting the flash drives. And then when the concern was raised about the victim's cell phone, we did the same thing, providing a flash drive containing those.
Victims' family members speak. Emotion rises in the courtroom as they express frustration, disappointment, and repeated delays. They question why problems are surfacing so close to trial after long anticipation.
Items as well. So what I wanted to convey in the letter is just that there's been times where we're surprised by discovery. We're meeting with law enforcement and then we find out there's something that they didn't turn over. This was different than that situation because it wasn't that there was something that we should have known about that we didn't know about. What we didn't realize is that it wasn't in a usable format when we provided it.
All right. Well, this incident occurred in August of 2024. That's 3 months shy of 2 years ago. This was set for trial in December, and I agree with your characterization. I think setting it for December was on an aggressive schedule, a very hopeful schedule that we could move forward and have trial in December. So when I adjourned it the first time, I had what I thought was a very realistic expectation that this would be able to move forward June 8th. I have that whole 2 weeks set aside. There's some other matters that I scheduled just in case, but the entire system was hoping that this would be able to move forward. I just want the parties to be aware of the efforts I've done on my end to make sure that this trial runs smoothly, and I understand you've been preparing for your prosecution and your defense. But I've been meeting with DPW, court security, bailiffs, the clerk of courts, IT. We've had to order more chairs so that we have enough seating for the jurors. We've reorganized parking lot structures and accommodated all sorts of IT, the system technology at the state level, the contractor also being on call during this trial in the event that something happens and some technology doesn't work. because technology fails. That's the way it is. And so just internally here with the clerk of courts, we've been working to make sure that technology doesn't fail. And if it does, we can fix it almost immediately. And so it's ironic that we had a technology failure when it comes to discovery. And I have a hard time understanding how this wasn't caught a little earlier, because the defendant and the victim are both of a generation where cell phones are what they use constantly, all day, every day. I'm not saying them specifically, but their lives could be on those phones. People text with each other when they're a room away. And it's constant, texting throughout the day, different social media sites, different ways to message people. And I thought that that would be at the forefront of this case, which is why I kept checking in with statuses and motion hearings, say, is there cell phone evidence? Are there different text messages that may be relevant, that may be other acts, that may be McMorris evidence? And I just kept being told, nope, we're set. We had at least 90 jurors return questionnaires that were 4 pages long. Every single one of those questionnaires has been reviewed. We have 129 jurors that have rearranged 2 weeks of their lives in the summer to be ready to serve their civic duty. And I'm really at a loss for the best word to articulate the frustration I feel, because disappointed is just a woefully insufficient, inadequate word.
The judge grants the adjournment, emphasizing fairness and the need for competent defense. New trial dates are discussed, stretching into late 2026. The court warns that further delays could push the case into 2027, highlighting the fragile balance between justice, preparation, and time.